Everyone, and good morning. Thank you for joining our webinar today, 5 ways to resolve your parenting matter without going to court. And that's always the aim, isn't it? So I can see a few more people coming in. So in the meantime, just drop in the chat box who you are, where you're from, say hello. Throughout the webinar, my team member Rory is going to be monitoring the chat box. Good morning, Rory. So if you've got any questions, he'll be there to answer them. We'll have some polls coming through probably around about now. So look out for polls, answer them as you go through. We want this to be as kind of engaging as and interactive as possible, and to keep you interested as well. So I can see we've got a whole range of people here, which is fantastic. And I don't want to talk about myself too much. I'm going to get straight onto the next slide, and I can see quite a few more people have just come through. So welcome everyone, and let's get going. So good luck trying to get this song out of your head. When I put the slides together this week, I've had this song in my head all week. So who are you? I'm not going to sing, but who's this webinar for? Well, I can see we've got some people who have separated, so parents who have separated, and this really is for you, okay? So it's really going to be helpful, I think, as well for service providers. And I can see already we've got some service providers from Sydney, Newey or Newcastle. We've got some from, who else? We've got Queensland, Rockhampton and Adelaide. So we've got quite a few here already. You service providers, you're dealing with parents all the time. You're helping them navigate this family law system, this difficult system. So really it's going to be useful for you. I could see in the sign up as well, we've had a huge number of people sign up for this webinar, lots of legal advisors, so from community legal centres, legal aid as well. So if that's you, say hi in the chat box as well. The webinar is not going to be overly technical in terms of the law. So for those legal nerds, you might be a little bit disappointed, but we're really gearing this towards you, the person who has separated. So what we're going to cover today in a nutshell: where to start. Where do you start when you've separated and you're trying to navigate arrangements for your children? We're going to talk about myths and misconceptions. We're going to talk about things such as 50-50 custody. We are going to talk about parental responsibility, different ways that you can resolve your parenting matter, of course, 5 ways, that's what I promised. We'll have some practical tips. And then at the end, there'll be a bonus offer, so stick around for that. Also, I should have said as well as at the outset, stick around. The handout will drop down towards the end of the webinar, so stick around for that and you'll see that drop down. It drops down kind of where you see all the polls, I think. When you're starting out, and I'm sorry, I haven't done a webinar for a while. I just lost my spot on the slide, and that's because I printed double-sided. It's very conscious of me in terms of the environment. Here's my caveat. This is not specific legal advice. It's general information only. And I'm going to say you, your ex-partner, your matter, your children. So obviously that's directed towards parents. If you're a legal advisor or a service provider, just keep that in mind. Next slide. There we go. There's my caveat. Now, this is not just a shameless plug for my first book, Separate Ways. A little bit of a plug, but not a complete plug. I just want to pause here and really reflect and keep in mind for you as the parent, as the person who's separated, that separation can be one of the most traumatic experiences that you ever go through. So don't lose sight of that. Don't lose sight of that as a legal advisor or someone in the family law space as well. I think when we've been in it for so long, we forget how hard it can be for parents. But you're here, you're in the right spot, and you're arming yourself with knowledge and giving yourself as much control as possible. Now, here's another song you might struggle to get out of your head, and I apologise for that. Another pause just to remember that your separation is unique. So everyone's got their own family law story. Every family's different. And don't be fooled by those myths, okay? So you're doing the right thing being here, getting some more information, but turn to things such as newsletters, websites, legal blogs and articles. In terms of your friends and family, here's a tip for you. They're well-meaning, but often misinformed. So lean on your friends and family for that emotional support. Just beware in terms of getting any sort of legal advice from them. And likewise, I always include this slide. This is one of my favourites. Don't be getting your legal advice from the hairdresser, your barista, and please don't confuse your Google search with my law degree. Okay, let's get into it. And I can see that we've got quite a few service providers that have joined the webinar from places such as Centre Care Relationships Australia. Here's some parenting courses that I recommend for all parents who've separated in the first instance as part of that arming yourself with knowledge. So we've got Circle of Security there. There's a really good Kids Are First program as well, which is recommended by a lot of lawyers, a lot of people in the family law separation space, and often ordered by the court. So if you're a service provider and offer a parenting course that you think is really helpful, can you drop that in the comments as well? I think that would be really helpful for people who are watching along. And certainly I know, for example, Circle of Security, Kids Are First, they're courses that a lot of our clients have some resistance to going to initially, but almost always report back that, you know, they actually got something out of it. So when we start out, we're going to get into the 5 ways shortly, the 5 ways to resolve your parenting matter. That's why we're here. But I want to rewind a bit, because before we get to that, we really want to know what the law says, because that's always, and I'm more of a dog person, I must say, but for some reason, some cat memes got into this presentation. But what does the law say? So we need to know, what does the law say when parents can't agree around arrangements for their children? What does the law say? Because until we work that out, it's really hard to go into the different ways that we can resolve it. So I want to reinforce at this point, I think it's a good point to reinforce and really reinforce that you as a parent can agree on whatever you want, whatever arrangements you want for your children, as long as it's safe for them and there's no welfare concerns. These are all guiding principles. We're going to talk about what the law says, but ultimately, as a parent, you can make those decisions for your children as long as there's agreement with your ex-partner. Just move on to the next slide. Alrighty, let's get into some myths. And of course, I must say as well, the better your understanding of the principles of the law, the more likely you are to reach an agreement. So the first myth is around the rights of parents, you know, my entitlements, my rights to spend time with the children. And for this, I'm going to blame the legislation, and thankfully there's no judicial officers who've tuned in. I presume they haven't. I'd be concerned if they had, because they should know it all. But the legislation was amended back in 2006, and at that time it was amended to provide for what's called this presumption of parental responsibility, or equal shared parental responsibility. And the exceptions to that is if there's family violence. And what is parental responsibility? And I think this is where some of the confusion has come, and you'll see some of the confusion around those, well-meaning friends and family and the social media and people on social media who talk about parental rights. So I'll make this slide bigger for you, and just a reminder, the handout will drop down towards the end. So the starting point, I think, is what is parental responsibility? So parental responsibility in relation to a child means all the duties, powers, responsibilities, and authorities which parents have towards a child. So it's not a parental right, and it's not an entitlement of the parent. It's the responsibility that parents have towards children. So what is parental responsibility? Well, when I explain it to a client, I tend to explain it as like a big ticket item, if I can put it that way. So we're not talking about the care arrangements of children. We're not talking about where they live, how much time they spend with you each. Parental responsibility is those big ticket items such as their education, their serious medical needs, their dental needs, their religious upbringing. They're examples of parental responsibility. So parental responsibility is very different from time arrangements and spend time arrangements. And it's not to be confused with equal time. And I think that's where a lot of confusion comes in with the general public. So just in terms of the next slide, when the court makes a parenting order, what the law says, and I'm talking about the Family Law Act, what the law says is when a parenting order is made by the court must apply the presumption that it's in the child's best interest for the parents to have equal shared parental responsibility. So those equal responsibility for those big ticket items. And as often is the case with the legislation, there's an exception. And the exception is that presumption for the equal shared parental responsibility doesn't apply if there's reasonable grounds to believe that there's been child abuse or family violence, or if it's not in the best interest of the child for that equal shared parental responsibility. So I hope I've not lost you so far, and I promise the technical slides will finish soon. But just going on from that 50-50 myth around the shared custody and just reinforcing that equal shared parental responsibility is not a presumption of equal time. So there's no presumption of equal time. And this is where it can get a little bit more confusing around the shared care, because if the court makes an order for equal shared parental responsibility, then it has to consider whether those equal time arrangements or shared care is suitable for the children. But just because the court has to consider it doesn't mean that the order will be made. And it's always going to come back to the best interest of the child being the paramount consideration. It's always going to come back to that. And, that again takes us back to the slide from Adele's song, because when you're looking at, well, what is in the best interest of the child, this is going back to every family's different. Every child is different. Every children's need is different. So how do you determine what is in the best interest of the child? So there's a number of ways. And just to go back, to remind you, the reason this is relevant, because it might seem that I'm getting too technical or too off course, or this doesn't apply to you because you're not in court. But it is relevant because the law is the guiding principle, and your fallback position, if there's no agreement and if your hand is forced down court, and I hope it's not, but if it is, it's always going to come back to this. So this is a really good starting point for consideration. So how does the court determine what's in the best interest of the children? Well, there's a few ways. There's what we call primary considerations, which I guess is self-explanatory. The first is, and this is set out in the Act, that children have the right, so again, it's the child's right, not the parent's right, to have a meaningful relationship with both of their parents. The second primary consideration, which is actually going to override anything, is that it must be safe for that to happen. So the court has an obligation to protect children from harm. So they're the two main things: the right to have the relationship, a meaningful relationship, but also to ensure that children are being protected from harm. Then we've got this whole list of additional considerations, and I've listed some of them there on the slide. But we've got things when we're looking at what's the best interest of the children, things such as their views, the relationships that the children have with both of you as parents. So is there a history of a relationship? Have they spent time with you regularly and consistently? The court looks at things such as practical considerations, so where you're living, your ability as a parent to look after your children's needs, are there concerns in relation to your parenting capacity? We look at cultural considerations, and the law also specifically sets out the requirement to look out for and be considerate of Aboriginal Torres Strait Islander considerations as well, and that connection to culture, and family violence. So when you're looking at the best interest of children, you're looking at, are there any family violence considerations as well? So if we're looking at a particular family, and we're looking at the family dynamics and what might be best for children, we're doing just that. So we're looking at the family dynamics. We're looking at what's the day-to-day needs of your child, of your children. Every family's different. What's been happening since you separated? Has there been one primary carer? Have there been arrangements that have been placed in for 12 months already, for example? And if so, why would you change that? How is it in the child's best interest to change it? How far apart do you live geographically? So, for example, I used to live in North Parramatta. If I lived in North Parramatta and my ex-partner was in the Northern Beaches, how would that work in terms of children going back and forth? Because those of you who are from Sydney or have lived in Sydney knows that that's just not practical, okay? What are your work commitments? What's your capacity and availability to care for children? So they're things to consider as well. And you're always looking at, it's always going back to what are the child's needs, and is it possible, is it possible for them to stay living in the family home? Is it possible for them to retain or stay at the same school and to keep those friendships and keep some consistency in their life, given everything that they've been through with the separation? Do your children have any particular special needs in terms of intellectual disability or autism, or do your children need and thrive off structure and routine? Do they have sort of educational supports in place that need to be maintained? And is it going to be in their best interest to be, distanced from that? The 2006 amendments, they're not directed towards parental rights, but they're couched so that the child can have a meaningful relationship with both of their parents. But you can see it's really not a one size fits all. So the big question we get all the time, and you'll see this all over social media, is around shared care. And when is it appropriate? When is equal time appropriate? Excuse me, I'm just having a cup of tea. And feel free to pop it in the chat box, any thoughts that you have around this as well. But generally speaking, when equal time or shared care can be difficult are in circumstances where children are very young. There's high conflict matters. There might be difficulty co-parenting. Your parenting styles are different. Geographical distance. So as I mentioned, the Sydney example as well, that can make it difficult for shared care type arrangements, and the special needs of children. On the flip side of that, when shared care type arrangements may be appropriate is where there's amicable communication and good co-parenting, children are safe and well adjusted, and close proximity to each other as well. And I like to call it the parents can do face-to-face teamwork. So face-to-face teamwork. So parents have a view and a goal to sit down with each other face-to-face and really work through what is best for their children. Obviously, not high levels of conflict and not family violence or welfare concerns. They're the sort of types of situations where it may be appropriate for children to have a sort of shared care arrangement. But it really, when I'd say the age of the children, this is where I'm talking about attachment theory. And I know we've got a few people here, and I can see, for example, Joe working as a parenting coordinator. Hi, Joe. Thanks for joining us. Jo, you and other practitioners that have joined us probably have some views around attachment theory and, that magical age number where equal time might be appropriate. Love to hear your views in the chat box. The research and the reason for this is because the social science research differs. I'm going to talk about what the court thinks and what the court says, but different practitioners listening will have different views perhaps, but what the law generally follows and what the court generally says and the attachment theory literature that the court follows is that from the birth until the age of 4, that's when kids are really vulnerable, and that's when their attachments are generally established between the age of 0 or birth and 4 years old. And during that time, that's where their attachments are established, and that's when it's better for them to have, or more appropriate for them to have, a primary carer. It's quite rare, in my experience, through court proceedings, for example, it's quite rare, and a lot of the work I do is where I represent children, quite rare that the judge would make an order for a shared care type arrangement for a court matter. Now, that said, that might be because a lot of the matters in the court system don't have those elements of co-parenting, amicable relationships and courteous relationships as well. But generally speaking, in my experience, there's not many situations where a judge would make an order for a shared care type arrangement for a child under 5. I just want to take us back again. If you're the parent that's listening and says, oh, but my 3-year-old, they've transitioned really well back and forth between our houses since we separated, perfectly fine, and a reminder that every family's different and you do what you want. So you use this as a guidance, but if you and your ex-partner can agree on that and your young child is well adapted, that's perfectly fine. On the flip side, you may have a 10-year-old and obviously older. Now, that 10-year-old may have a strong attachment to one parent and not the other, and really struggles to move from one household to the other. That's just an example I use in terms of how every matter is unique and every family is different. So just moving on to the next slide, and there's only a couple more slides in terms of legislation, so just giving you that reassurance. But with this slide here, what this is around is where there's arrangements in place that, says that the children live with one parent for most of the time, or a primary residence. What the law says is that the children have the right to spend substantial and significant time with their non-residential parents. So what does that mean? Well, it doesn't necessarily mean shared care, and it doesn't necessarily mean overnight time only. And it's normally a focus around quality over quantity. And I think if you're looking at it from a child's point of view, if you've got a young child who's not spending time with their non-residential parent for, say, 2 weeks, that 2 weeks for a young child, or for any child, can seem like a lifetime. It's such a long time. So for babies, toddlers, younger children, if they do have that primary attachment and the primary residence, keep in mind it can be really good for them to have more frequent, shorter periods of time and quality over quantity with the non-residential parent. And when you're talking about and thinking through what might work best for your children, the other thing I think is really good to keep in mind is that if you're keeping your matter out of court, you can do sort of what we call interim arrangements or some short-term arrangements and put things in place that might be best for your child now, but not necessarily later, because their age is going to change, their developmental needs will change, and your situations change. So can you put in place a shorter term arrangement now with a view to, reviewing or increasing the time at a later date? I think that can be really a good child-focused way to look at the arrangements for the kids. And before we go on, I just want to, really reinforce at this point, because again, going back to how difficult this can be for parents, and as a parent, not being able to have your children live with you when you separate can be really difficult. And I just want to recognise how difficult that can be, but also concede that, it's not in the best interest for all children or all young children or any child to have equal time. It's just not in their best interest. But if you're not having equal time with your children after you separate, or not even overnight time to start off with, that doesn't necessarily mean that you're less capable of your parenting. It's really just focusing on what's best for your children at that particular time. Now, the other thing I just want to pause and say here as well is that everything I've just said, so going back to everything I've just said, is probably not going to be appropriate for you if there's been welfare or family violence concerns in your relationship, or, if the children are at risk of harm. And if that's the case, it may be that it's not appropriate for the children to have any time at all with the person who's placing the children at risk of harm. It may be, it may not be, but in those circumstances, if there has been family violence, I really urge you to get some legal advice. So I'm going to bring you all back now. So those of you who have drifted off and perhaps doing some emails and I got a bit technical and boring with the law, you'll be pleased to know that has finished, and we're about to delve into the 5 ways that you can actually, from a practical perspective, resolve your parenting matter. So now this next slide is one of my particular favourites. Why do you want to stay out of court? No one ever. So I've been practicing for nearly 20 years. Or not practicing. That sounds like I'm still learning. Well, I am learning, but I've been working as a lawyer for almost 20 years. No one's ever left the court and said, gee, that was fun. That was a pleasant experience. It's not. Okay. So this is why we want to stay out of court. It can be costly, paying legal fees, having time off work. It's stressful. It is stressful. No matter how resilient you are, it's not a pleasant experience. And I think importantly as well, if you end up through that system, you're almost certainly going to undo any opportunity that you have with your ex-partner to be able to co-parent in the future, because court proceedings can really bring out the worst in each of you, and you're essentially encouraged to file affidavit material outlining the worst parts of your ex-partner, the concerns you've got about them, and how the children are better living with you than the ex-partner, and so on. It's not a pleasant experience, and it's not good for any future co-parenting opportunities. The other reason that it's so important to consider the different ways you can resolve your matter outside of court is that the law actually changed. So back in September 2021, the family court structure changed, and it's now a merged court. And from that time, there's now more emphasis and requirement for you to attempt to negotiate your parenting matter outside of court. There always was, and my practice always was, and the court did require it, but there's now more emphasis on that. So let's get straight into number 1. Now, this is going to seem really straightforward, and it is straightforward, but number 1 is a way that sometimes is overlooked. Direct negotiation. If it's safe to do so, and if you've got a relatively amicable relationship with your ex-partner, why not directly negotiate? It can be quicker. It's certainly more cost-effective, and it can be really good in certain circumstances. It enables you to agree on whatever you want, so you don't have anyone, putting their suggestions forward, or worse still, a judicial officer making a decision. But it can be really good in terms of ongoing co-parenting. So please don't overlook how powerful sitting down with your ex-partner with a coffee, trying to work through the best interest of your children can be. Obviously, that's not for everybody, okay? Not for a lot of you, but for some people, it does get overlooked, and some people are really quick to look for legal alternatives or mediation alternatives. But sometimes, parents are able, in some circumstances, to resolve things themselves. Number 2, community-based FDR. FDR means family dispute resolution. I think we've got some of you here today, so I'd love to hear from you in the chat box if you are an FDRP. FDRP is a mediation practitioner. So these services, such as Relationships Australia, the Family Relationships Centre, and Centre Care, these sort of services, and I think we've got Pascale here from one of the services, they offer a mediation type service to assist the parties, and that's emphasis on assist, to reach an agreement. So these trained practitioners, they're not decision makers. They can't make a decision. They can't enforce a decision, but they're there really to guide the parties through the mediation session. And generally what happens, it depends on the particular service, but some services require a sort of information session or a parenting course to be done first. There'll then be an intake session where you can outline any concerns that you've got, or really outline the goals and things that you're hoping to achieve from the sessions. And then the parties come together for a joint session or a joint series of sessions. So it might be more than one session, which is really helpful. And the goal is to reach an agreement around where the children live and how much time they spend with both of you. Just repeating a few things there on the slide. I think we've gone through that. Worthwhile mentioning that process is confidential. So the exception is if there's an agreement that's written and signed. But aside from that, whatever happens through the mediation process is confidential. So it's really good because it encourages negotiation in a safe space without feeling like there's judgment or consequence for things that you might raise, or proposals that might be put back and forth. So it really encourages negotiation. It's a voluntary process. So if you invite your ex-partner to participate in the community FDR, they don't need to attend, they don't have to. And likewise, if you receive an invitation to participate, you don't have to. I'm not advising you not to attend, okay? In majority of the situations, or majority of family situations, it will be recommended that you do attend. There's a few reasons. Aside from retaining some control over arrangements for your children and avoiding court, if you don't attend, your ex-partner will be issued with what's called a Section 60I certificate, and that's essentially the ticket to enable you to go to court to say, I've ticked the box, I've tried and it was not successful. Same goes if you do participate in the mediation and it's not successful, no agreement reached, that certificate is usually issued as well. So get some legal advice before you flat out say no. Get some legal advice, because they in my experience, they're a really good service, and I really, I rate those services quite highly as well. I'm just looking through my notes. I've got some do's and don'ts from Relationships Australia. Anyone here from Relationships Australia? If so, I've stolen this from your website. Here's some do's and don'ts, which I'll let you read. And I think as you're reading through them, those do's and don'ts really apply for any negotiation post-separation. So not just these community-based FDRs, but any sort of negotiation. I think they're just, I think Relationships Australia has summed that up nicely, which is why I've stolen it. Okay, so with credit though. The third way to resolve your parenting matter without going to court is sort of similar. FDR, family dispute resolution, but on a private basis. So these services, there's quite a few online now, which is good as well. Similar to the community-based ones, so in terms of what I've run through, but they can be more quicker. They can be quicker. They are generally quicker in my experience. They're also more expensive. So if you're on a low income or on a Centrelink benefit, it's probably not for you. But if you are someone who, has is able to afford it, then their services, and you need a service quickly, they're very good services and I'd recommend them. An extension of that is that you can also, I guess this is a 3A. I could have almost made this a 4, but a 3A is a private mediation with lawyers to assist. And this is something that we do quite a bit of. And we can actually attend the joint session component with our client. So normally what happens is that intake session is one-on-one with the parties. But then when it comes together for the joint session, either if there's one or two lawyers can come along. It might be just one lawyer for one party and the other party self-represented, or both may have lawyers, but that's another option as well. And that can be really, I find that quite efficient and quite enjoy doing those type of sessions, very child focused, but also having the lawyers involved with the legal knowledge can really help to seal the deal, if I can put it that way. The other thing I like about those options where the lawyers are involved is if there has been family violence or a power imbalance, I don't want you as a parent to think, oh, mediation's not for me because, I'm either, scared going into that process. I'm worried there'll be power imbalance, or I'll be bullied into some sort of arrangement for the kids, or there'll be a proposal that's not best for the kids. When you've got the lawyer-assisted mediation, you're probably going to do a shuttle type mediation, so you're not in the same room with your ex-partner, and that power imbalance is a bit less of an issue. So I find that really good in terms of, for some matters, to avoid court, okay? Because you don't have to do this to go to court. If there has been family violence, you don't have to try mediation. But my personal view is that for some families, it's still best to try mediation if it's safe to do so, to keep you out of court, which is, it's re-traumatizing. This takes me to number 4, and this is a legal aid type service. Now, I've put the website there on the slide, and this website's for the National Legal Aid organisation. So that will bring up, no matter what state you're in, you can go on there and find which legal aid service is relevant to you. And these legal assisted mediations are where at least one of you has to have legal aid funding. So you don't both need it. So if one of you is on a low income or on a Centrelink benefit, you probably will get the funding. And if your ex-partner is employed, it doesn't matter. You can still use their service, and they're very good service. And you'd be surprised, actually, some of our clients who are on a lower income, they don't qualify for ongoing legal aid funding in terms of substantive court proceedings and so on, but they will get funding for the legal aid conferencing. So if you're not sure if you're going to qualify for legal aid, I always say have a crack, give it a go. There's nothing to lose there, and they're really, really good services. So I've done them in a few different states. Generally speaking, they'll go for a 3-hour block. You don't have those intake sessions like you have with the community-based FTRs or the private FTRs. You have the 3-hour block of time, and the practitioner is also able to issue those Section I certificates that I spoke about. The difference with the practitioners at the legal aid commissions, no matter which state you're in, is they all have a family law, a legal background. So most of them are 10, that's probably generous, most are closer to 15 to 20 plus years experience as working as lawyers, but they also have this focus on trying to resolve matters and keeping them out of court and being very child focused. So with those legal aid conferences, about a 3-hour block, neither of you needs a lawyer. One of you can have a lawyer, or you both can have a lawyer, but neither of you need it. But if you apply for legal aid funding and you get legal aid funding, you'll be allocated a lawyer at that point. If you're going into it on a private basis, you can pay a private lawyer, or you can do it yourself. It's really up to you. So there's quite a few options, and I do recommend those services. Now, the last, number 5, is lawyer-assisted negotiation. So what we've got here is One of the ways that you might resolve your parenting matter is through a collaborative lawyer. Now, collaborative lawyers are really geared towards parties where their separation's relatively amicable, and they're really focused on staying out of court, so much so that if they have joint sessions with their lawyers and other professionals such as psychologists, and really focused on child-focused outcomes. If there's no agreement reached, when you're a collaborative lawyer, you can no longer work for your client. So if there's no agreement reached, then you as a client will have to go find another lawyer. So that's one of the downsides, and it can be a bit more expensive. One of the things that we do quite often at our office is just simple negotiation or proposals through letter writing. And it might look like it can be quite effective. It might be negotiating or putting a proposal to your ex-partner in writing around, look, little Billy, we're proposing that he live here and he spend this time and this school and these are the holiday arrangements and so on. Let us know your thoughts. That can be a good option for some parties, some families. Depends. You know your ex-partner better than anyone else. You know how they'll respond in mediation. You'll know how they respond to a lawyer's letter. You'll know, better than we do how to best be able to move your parenting matter forward and negotiate. Just pausing, I'm going to have a sip of tea. Thanks for your comments there. I can see quite a few people have commented. I'll try and get to them in a bit. But thank you very much for your comments. Recapping the 5 ways to keep your matter out of court. Number 1, direct negotiation. Number 2, community-based family dispute resolution. Number 3, private mediation. 3A is lawyer-assisted private mediation. Number 4 is a legal aid conferencing, with or without lawyers. And number 5 is lawyer negotiation. So, taking a step back, let's say you've reached an agreement. What now? Well, I'd say there's 3 options. Please comment in the chat box if you think there's more. Here are my 3 options. You've reached an agreement, whether it's interim or final agreement. Your options are these: parenting plan, consent minutes of order, or do nothing. Okay, so number 1, parenting plan. A parenting plan, and often in mediation, you'll be working towards getting something in writing. And if it's in writing and it's dated and signed, that's a parenting plan, okay? We've got a precedent in our online course there, you can see. But parenting plan can look like all sorts of things, but it's setting out the arrangements that you've got for the children in terms of how much time they have with you both, where they live, where changeover is going to be, what's going to happen in the holidays and special occasions. And yeah, really setting out your expectations. The beauty of it, I think, is that it really enables you to agree on all sorts of things, which as a lawyer, I'll call like the softer stuff. I know some of the community workers here won't like that, but the softer stuff, the stuff that the judges don't necessarily not care about, but they don't want to put in their court orders. So it enables you to say things like, be respectful to each other, and please comment if you've got any other softer stuff examples of things that you might put in your parenting plans when you're helping parents. But anything you want really as a parent, if it's important to you both and you want it included in your parenting plan, you can. So that's an advantage. It's cost effective. Yeah, it's cost effective, keeps you both in control of the situation, and it's easier to review. So you might have a parenting plan in place and you might say, okay, this is going to be in place for the next 3 to 6 months, and we're going to review it after that time. And you actually pop that in the parenting plan, your intention to review it. So it's all very clear. So it's easier to review as opposed to a court order. The cons, I guess, is that parenting plans are not legally binding. They're not registered with the court, so they're not a court order. That said, If you've got it written and signed and dated, and if things become terribly unstuck, and I'm talking worst case scenario, if things become really unstuck and you end up in court, if your parenting plan's signed and dated, you can attach that to your material, your court documents, and show the court. I always recommend, for that reason in particular, always get legal advice before you sign the parenting plan. And I think most mediation practitioners here listening would give that advice to parents that come through their service as well. Alrighty. Number 2 is, if you've reached an agreement, now what? So the second option is consent minutes of order. And I can see our handouts just drop down for anyone who wants to grab a copy of that. So consent minutes of order, these are when the agreement is drawn up and it sets out the living arrangements for the children. So it sets out, similar to a parenting plan, this is where the children live, this is how much time they spend with us both, this is where changeover is, this is what's happening on special occasions, Christmas, birthdays, school holidays, everything. Set out. The agreement and other supporting documents are registered with the court, but there's no court proceedings, okay? So you don't have to go to court. You don't have to appear before a judge. And the consent minutes of order, they're registered with the court, and then a registrar of the court, who's like a step down from a judge, looks over it, makes sure that it's all in order and seems reasonable, and then the court stamp or seal is put on it. And that has the binding effect of a legal court order that you both have to comply with, but you haven't had to go to court to get it. So they're not always needed though, because if your communication with your ex-partner is relatively amicable, and if there's a level of trust there, and you know that you're both going to stick with your verbal agreement or your parenting plan, why would you go to the cost of paying a lawyer to draft consent minutes of order? It's not necessary. Circumstances where it is useful is where, if there's not that complete trust, you want to ensure compliance. You don't want to be stuck negotiating every fortnight. You just want it there in writing for your own protection to know that it's going to happen. So for compliance, basically. I think that's all I wanted to say on consent minutes of order. Oh, no, that's not all. I'm a lawyer. There's always more to say. Get legal advice, obviously, before signing it. One of the issues with consent minutes of order or a court order is that they're more difficult to review. So they're usually drafted more as long-standing orders, long-standing arrangements. So that's where a parenting plan can sometimes be a bit better for review than a court order. And I'm not going to get technical with the law, but the legal advisors watching will know sometimes the difficulty of bringing a matter back to court to change orders if they're not working out so well. So that's one of the other reasons. Now, the third option, if you have reached an agreement, now not all lawyers will say this one, because it's not in our financial interest to do so. But the third option is just do nothing. All right. Sometimes our advice to clients is do nothing. If you've got that level of trust, if you know that you're both going to comply with what you've agreed on, you might not need a parenting plan. You might not need consent minutes of order. Another reason to just do nothing is you might have reached an agreement, but you think, oh, I'm not 100% happy with that. I feel like, I'm not happy with that. I don't feel like that agreement was really in my interest. If that's the case, it might be best for you not to sign a parenting plan, and certainly not to sign consent orders, because you're showing your consent. So it might be best just to keep the agreement verbal and try to review it. Every matter's different though, but certainly there are matters where just do nothing, because you don't need to, because there is that amicable relationship, there's that level of trust, there will be compliance, or it's not in your interest to sign. Now, this leads on to no deal. What do you do if there's no agreement? Well, go back and try again. So if there's a partial agreement on some things, or if there's just no agreement, I'd urge you to go back and try mediation again, or try one of those other 5 ways that we've spoken about to try to review and reach an agreement, even if it's a partial agreement. Try a different way. If a particular method just wasn't working for you, try a different way. Court should always be a last resort, and you're going to have to show that you've made an attempt to resolve your matter. So if there's no agreement, no deal, I'd just urge you to try again. And the next webinar we're going to run actually is in that worst case scenario where there's no deal and you have to go to court, what to expect in that court process. So if anyone's got any particular questions about that, please hit me up, because I'll put that in preparation for my next webinar. But I'm going to make this slide a bit bigger so you can read it. This has come from the Family Court website, or the Federal Circuit and Family Court, as it's now called. And I'll just let you read that for a moment, because that sets out the expectations of the court, and I think it's a nice reminder. And the other reminder I'd like to give you is the exemption. So if there has been family violence in your matter, if your matter's urgent, so there might be recovery type elements if someone's not returning a child, if you need injunctions, protective injunctions, court might be suitable for you. And I'll never advise a client to go to court if it can be avoided, but unfortunately for some people, that's going to be your option. So some matters are just not appropriate to try to deal with outside of the court, all right? Now, what else? I think we're wrapping up. Well, I know we're wrapping up. So this is the special offer that we have for you. So I've got 30% off. We've done an online course, Parenting After Separation, really 30-second rundown, 7 modules, 40 plus videos. We've got a parenting plan guidebook, and there's an e-copy of my second book there as well. So everyone that's here today, we're offering a 30% off, and that will be in your handout as well. But the code's, webinar 30. So I'd love for you to take that opportunity. If you're a service provider and you'd like some free access to that online course just to check it out, and so that you can suss it out and be confident that it is appropriate for your clients, which I suspect it is, let me know and I'll get you a free access code as well. So that's all I wanted to cover today. Pretty much bang on time. So what I'll do, thank you again, everyone, for coming today. It's been a really good turnout. What I'll do is I'll check the chat box later for any questions, and I'll get back to everybody individually. But thank you so much for your time. And while I've got you, I'm just going to check out the polls. Okay, so we've got about 60% from South Australia, 35% Eastern states. Half of you are separated parents. That's interesting. Service providers, 37% today. Legal advisors, 12%. I hope it wasn't too basic for you, legal advisors. Lots of you recommending community-based mediation. Depends on the family, 50%. If you're a separated parent, do you know much about attachment theory? 50% yes, 50% no. What I'd recommend to you guys, feel free to hit us up separately, but we can send you some resources, a bit more resources about attachment theory. Do you think children should always live with their parents on a 50-50 shared care basis after separation? 20% yes, that's interesting. I wonder if that came from parents or from service providers. And then I'll ask the question again later in the webinar. Do you still think children should always live with their parents on a 50-50 shared care after separation? 20% switched their view. 10% still said yes. Okay, well, thank you so much for answering those polls. That's super interesting for me. I think that's all now. I'm going to head off. I'll let everybody go. Thank you so much for your time. Look forward to joining you on the next webinar and sing out if you've got any questions. Thanks heaps, guys. I really appreciate it. Bye for now.